Well, let's turn now to taxation, finance and taxation in the Florida Constitution. Now, here's an area where we began filing up the Florida Constitution with Constitutional Revision of 1968. And I'll talk about that a little bit more later. But Article 7 now has provisions that you want to pay attention to as attorneys. You'll frequently get questions from clients whether or not you're a taxation attorney or corporate attorney or any type of attorney. You're going to get questions from clients and from fellow citizens about the taxation system, and at least you should have some understanding of how our tax system works in Florida. So our objectives on this section are to learn the large principles that control governmental financing of various kinds, to understand the system that allocates revenue between the various units of government. So who has the taxing power of a particular item? Is it rests with the state or with local government? And also, we want to look at the bonding system through which government borrows money. And that system becomes very important to people who are, for instance, in real estate development or other forms of law practice that require financing. And you'll find that private developers frequently find ways to use government authority to do bonding, to bond and finance their private investments. Okay, taxation, large principle, under the control of the legislature. No tax shall be levied except in pursuance to the law adopted by the legislature. And note that this quickly goes into a prohibition. No state ad valorem taxation shall be levied upon real estate or tangible personal property. So taxation of real estate and tangible personal property are left to the counties, the local governments, county school boards, water management districts. But the state does not have authority to levy real estate taxes or taxes on personal property. A provision that motor vehicles, boats, airplanes, trailers, and so forth shall be subject to a license tax. So if you own a very large boat or a very expensive airplane, you'll be taxed only through a license. You might view this as a form of exemption, but taking these types of property outside of the normal principles of taxation. And indeed, as we go through Article 7, we're going to find this constitutional provisions just honeycombed with exceptions of various kinds and special treatment of various kinds. And so we begin as early as Article 7, Section 1, with a special treatment given to motor vehicles, boats, airplanes, trailers, trailer coaches, and mobile homes, and so forth. So it's subject to a license tax. And as you look at those taxation systems, you may want to check and see how fair you think that taxation system is. But they shall not be subject to taxation based on their value. So these are now excluded from ad valorem taxation. So we take forms of wealth in property and say that you may not assess based on the value of those properties. Again, a very substantial loophole in fair and uniform taxation. A provision at the end of this section, Section C, saying that you may not draw money from the Treasury except pursuant to an appropriation. And then subsection D, a requirement that there always be sufficient revenue to pay for ongoing expenses. So no deficit financing for state government of the type you can get in federal government structures. Limit on revenues. Again, some limitation that's is tied to growth, but this serves as essentially as a cap on the revenues that may be collected. Section 2 on ad valorem taxation shall be at a uniform rate within each taxing unit. Now, when you read that, understand that you do not have the full import of the Florida Constitution on taxation until you finish reading Article 7, and we're going to find some terrible departures from these principles of uniform taxation. Again, this does allow exceptions for intangible personal property, maybe at different rates, not to exceed 2 mils on the dollar of excess value. Now, Section 3, taxes and exemptions. I'm sad to say that our taxation system now is absolutely shot through with exemptions of various kinds, a number of them coming out of the Constitution, and as we'll see, but where the legislature has authority to create special categories or special exemptions, it almost always accepts that authority and uses it and provides ways to turn our uniform taxation system into a system that is less fair. So again, we have to trace through, for purposes of this course, what's in the Constitution. And so we begin with municipal property. Now, note the importance of this language and note what it includes and what it does not include. This does not relate to local government property. It relates to municipal property. Now, for municipal property shall be exempt so long as a local government can show that it owns the property and that it's used for a municipal purpose. Now, if it's not used for a municipal purpose, it may not be exempt. So municipal property is under the Constitution treated differently from county property. Counties enjoy the sovereign immunity that the state is given, and so the state property is not subject to taxation, and county property is not subject to taxation under the Constitution. This provision also allows for property that's used predominantly for educational, literary, scientific, religious, or charitable purposes to be exempted by general law from taxation, and we have large numbers of those exemptions in the law governing taxation. Personal property exempt, exemptions of $1,000, and exemption for the blind and totally and permanently disabled. Again, the legislature has provided general law in this area. Now tax exemption for economic development. Again, you start piling exemptions on exemptions and think about what you do to the tax base. But the Constitution begins these exemptions, and the legislature seizes every opportunity to implement these exemptions. And so this provision allows general law to provide exemptions for a new business and expansion of existing businesses. Think about the fundamental unfairness of this. A new business comes along and gets an exemption from taxation, And what happens to the people who've already had businesses in Florida? They now will carry a disproportionate share of the tax burden, and isn't that a competitive advantage for the new business? But yet that's the policy that our state constitution sets up. An exemption is allowed for historic preservation. Again, I applaud historic preservation, but I worry a great deal about the use of all of these provisions which have been implemented by the general law. And so general law has been adopted providing for historic preservation, and that may be fortunate for some of our local governments, and may have preserved some of our areas from the devastation of modern development. Exemption for tangible personal property, $25,000. Exemption for conservation, real property which is dedicated in perpetuity for conservation purposes, including real property encumbered by perpetual conservation easements. So perpetual dedication for conservation purposes now can provide for an exemption. And that seems to me to have a sound public policy basis. You now can create, and the possibility of creating a green belt effect by having these exemptions for conservation, so long as it is perpetual dedication. We'll find that legislature and the Constitution allow some further departure from these principles of perpetual. Agricultural land, land that's producing high water recharge for aquifers can be assessed and classified solely on the purpose of a character of use. So the legislature has used this language to allow for agricultural assessment. I confess, I sponsored the law that originally provided for agricultural assessment in Florida, and I regret it a great deal. We should have had in that law a recapture provision, which says that once you convert the land from agricultural land to other uses, there should be a recapture of taxes. And other later efforts to put in a recapture provision have simply failed. So we do have agricultural exemption and exemption for non-commercial recreational purposes. And you find some counties that have very large portions of the county are classified as agricultural. Again, classifications, allowing classifications for conservation, for stock in trade, that is the inventory of businesses, and given to the legislature the authority to make those classifications. Now, look at subsection B on conservation purposes. Remember, we looked earlier at a provision that related to land that had been dedicated in perpetuity for conservation purposes. But we also have a provision here that land used for conservation purposes should be classified by general law. No requirement of perpetual dedication. And this, in my judgment, is very bad public policy. Now, save our homes. If you want to think about why we have this provision in the Florida Constitution, look at this chart. Look at the line of normal inflation, and look at the bubble, the real estate bubble that occurred in Florida. We've had several of those bubbles in Florida history, but here's one in terms of recent history that shows how property values, how sale prices of property have escalated over a period of time. And so as you look at these lines, look at where this blue line, for instance, now begins to depart from the normal trend line and jumps up suddenly to this bubble. Same thing with the orange line, which is, I believe, the sales price of homes. It now jumps up well above normal inflation. And so what happens now is if you have assessments that are taking place along, that are based on the value of property that are back before the bubble starts, before that line starts jumping upward, and then suddenly people are faced with these larger assessments because the assessments are being based on the study of the sales of property. And if you study the sales of property and the value of property according to the sales data is increasing by 12, 15% a year, you suddenly have people's taxes escalating even though they don't change the ownership. And so what the Florida Constitution now does is puts in the Save Our Homes provision. It is, in my judgment, terrible policy again, but it is the law of the state of Florida, and it essentially says, through this complicated language, which we'll walk through, essentially says that that you're assessed not based on the value of your home, but instead based on the value on the sales price at the time that you purchase your home, beginning, I think, in 1996. So we get people who own their homes in 1996 now pay taxes based on what they paid for their home. Somebody who comes along in 2000, after this bubble has started and has paid a great deal more, will now be taxed at a higher rate, even though they have the same property. So identical property is taxed at a different rate, on a different basis. The assessment is different on the earlier owned property than on the later owned property. And this, in my judgment, has important constitutional dimensions which have not yet been fully resolved by the courts. Note that, this provision allows for an escalation of taxation of assessment of 3%. So the value can increase by 3% each year. But if the real value of your home is increasing by 12 or 15%, and the Constitution allows the assessment only to increase by 3, that means that your escalation of assessed value is going up gradually, but someone who comes in at a later time pays, is assessed on the value of the property at the time that they purchased it. More of the Save Our Homes language, it all now to this point relates to assessment based on the purchase. It now allows for assessments to be changed based on additions or changes to the property. And then at the point that you terminate homestead exemption, let's say you sell it to someone who does not use it as their primary home and is not eligible for homestead exemption, the property shall be assessed as provided by general law. So at that point, it's no longer homestead property. It loses its character that qualifies it for Save Our Homes treatment. And now another provision of Save Our Homes was put in later and really further complicates the application of the Save Our Homes principle. And this is principle of severability. Now, when the Constitution says that something is severable, it means that you now find some portions of this unconstitutional. You then still enforce the provisions that are not found to be unconstitutional. And now what I started talking about just a moment ago, what I really started talking about was portability, which again is a terrible idea for reasons that I want to discuss in just a minute. But portability now says if you have this, in effect, benefit that gives you special treatment under the tax law, and you sell your home and buy another home, you now can take with you this portable Save Our Homes right. So you now can take this from one home to another home. And the provisions of portability are spelled out in subsection 8A. And so the determination of value of a new home is the just value of the new homestead minus an amount equivalent to the lesser of $500,000, or the difference between the just value and assessed value of the prior homestead. So there's a portable tax benefit that you can carry with you as you move in Florida. So let's think about Save Our Homes. Let's assume that we have two owners of condominiums. Mr. Abel buys his in 1995 for $100,000, and Miss Baker pays $225 for hers in 2004. Mr. Abel is going to be assessed, this condo is going to be assessed at $100,000. Miss Baker will pay, property will be assessed as of 2004 for $225,000, assuming they're both homestead properties. Each of them will have an escalation, no more than 3% basically each year, but it's going to take some time for Mr. Abel to be assessed as much as Miss Baker, even though in a hypothetical, the properties are absolutely identical in value. So we no longer have a system of uniform state taxation. We have this Save Our Homes principle, which is overlaid on a system of uniform taxation, and we have something that now operates to the advantage of the people who have later come and purchased their property. Are they constitutional issues? I think they are, but I must confess I've handled several cases in which I've tried to raise these constitutional questions and I've lost. So our attempts to get the Florida courts to decide the cases failed, and attempts to get the case before the U.S. Supreme Court has failed. So right now we don't have any case law to support the proposition that I now like to put forward, and that proposition is that Save Our Homes is a violation of equal protection principles, even those very restricted equal protection principles that apply in tax policy. And most important, it's a violation of principles, federal principles, of privileges and immunities. Supposedly, under the privileges and immunities provisions that are included in the U.S. Constitution in Article 4 and in the 14th Amendment, we now have the same rights as all the citizens in states to which we move. Well, let's think about how this works out, and let's play with hypothetical. I want you to assume for a moment that other states, and let's assume New Jersey, now adopt Save Our Homes principles that are exactly like those in Florida. And now I want you to think about the New Jersey resident who has a large home, decides to retire, and they're now going to decide where they want to have a new, smaller home. And a possibility is to come to Florida. The weather is so much better in Florida. An awful lot of the real estate market in Florida is driven by people who move from northern states to Florida, go look at northern newspapers and you'll find housing ads by Florida real estate companies in papers in Detroit and New York and Rochester and other sunny places. And when you do see all these ads, you realize that there is a strong market for Florida real estate in these northern counties, northern states. So now a state adopts Save Our Homes provision, and that person in New Jersey, hypothetically, is making a decision. Are they going to sunny Florida, or are they going to buy their second home in New Jersey? If they come to Florida, if they have provisions similar to Florida, they're going to lose their tax benefit. And so they'll have to come to Florida without the tax incentive that New Jersey has given them. If they stay in New Jersey, because of the principles of portability, assuming that New Jersey has adopted such laws, then they can take their Save Our Homes tax benefit with them, and therefore, in terms of economic analysis, they're going to be pushed, I think, to stay in New Jersey, and that if that happens with a large number of states, it will undermine Florida's real estate market. So this, what I think is bad public policy, to correct a situation that could have been corrected in other ways, now potentially could play out in ways that actually harm Florida and Florida commercial interest. And so again, in case you're in doubt about it, I don't like Save Our Homes. I think it's a terrible departure from the principles of uniform and equitable assessment, and it's tragic that we've gone so far down this line. Now, historic preservation, there are provisions that allow the legislature to provide for historic preservation, again repeated in subsection E. There are provisions relating to legislative authority to give counties permission to treat specially the improvements that are made for grandparents. Now, I'm all for special provisions that give special benefits to geezers, but this is another departure from principles of uniform taxation, and we ought not to be engaged in all of these departures, because we wind up with a tax base that really simply cannot sustain the cost of government. Again, legislative provision to allow special rules relating to changes in improvements in property that would give protection from hurricanes, and also special rules relating to installation of renewable energy sources. Special rules relating to working waterfront property. So the idea comes into the Constitution because supposedly a marina being on the waterfront is going to be subject to taxation at high property values because of the value of the land, which could be used for purposes of an apartment building rather than a marina. So again, these ideas have a germ of good public policy in them, but there's no provision for recapture once someone turns the property from a working waterfront property into a condominium property. There's no recapture of the taxes that otherwise would have been assessed, and therefore I think this is bad public policy. Homestead exemptions. Bar examiners love this section of the Constitution. I'm convinced that most bar examiners have not read the Florida Constitution, and they think that this is fascinating. I find it really rather boring, and a subject that I assume that you covered when you took property law. So I'm not going to linger on homestead exemptions. It's a provision that came into the Florida Constitution, I think originally in 1868, and has expanded over a period of time. And the value of the property that can be subject to homestead exemption has expanded over a period of time. Let's go to Section 7, Allocation of Pari-mutuel taxes. These are the taxes on racetracks, high life frontons, and so forth. This is an issue of historical equity. When pari-mutuel racing was first allowed in Florida, small counties did not want to see it come about, and they were promised that they would get an equal share of all the tax revenue that came out of pari-mutuel wagering. And so that provision for equal treatment is one of the alternatives available to the legislature under Article 7, Section 7. So the legislature may either take the taxes into general revenue for the state, or it may allocate to the counties. But if they allocate to the counties, Liberty County then has to get the same share as Dade County. So there's an option for the legislature, and one the legislature can use depending on the political forces at the time. A provision allowing appropriations to local government. This obviously is not necessary. If it were not in the Constitution, legislature could appropriate to local government. But this last sentence is important because this now allows the legislature to use the relative ad valorem tax assessment levels determined by a state agency. This is a reference to sales, to tax assessment ratio studies. Are the assessments in line with the sales value? And this becomes very important, particularly important before I save our homes, distorted our taxation system. Again, provision providing authority to the legislature to use that determination by state agencies.
And there in subsection, this is in 199.023, subsection 1D, there's a reference to all leasehold or other possessory interest in real property. Now, it seems like to me that doesn't include equitable ownership interest in real property. And so that's where I don't know that your statutory argument really works, because the legislature had said, had included a reference to equitable ownership. That would be a different matter. But and the other point that I would just point out and get you to respond is that we know that in Florida law, the concept of equitable ownership is an important concept in this context, because in our case, the Leon County Educational Facilities Authority case back from this court in 1997, we said the concept of equitable ownership in ad valorem taxation has long been a part of Florida law. So that's part of the backdrop of what we have to understand the legislature is operating on. And given that, I'm having trouble understanding how an interest that could be determined to be a equitable ownership interest is going to be pulled over into the treatment of the intangible property category, a treatment that you're seeking.
Your Honor, there are two questions. First of all, as to the Leon County Educational Facilities Act, remember that the court found that was a financing arrangement. And so...
well, I'm not really relying on the holding there. I'm relying on this general principle about equitable ownership being part of the...
Good. So, Your Honor, in answer to that, let me put forward two propositions. One, the statute itself. The statute you're reading from, I believe, says such leasehold or other interest
Actually, the statute I'm reading from, the statute you're reading from, refers back to the if I've got this straight, refers back to the 2005 statute that I'm referring to, and it refers to all leasehold or other possessory interest in real property, which I think is a category that's distinct from the category of equitable ownership.
Your Honor, how do we read possessory?
Well, that's what the first DCA has. That's the way they've analyzed it. Am I correct?
I think that's right, Your Honor. Your Honor, the first DCA clearly went to this benefits and burdens analysis. In the Ward versus Brown decision, of course, the author is sitting on the court, so I'll not try to say what motivated the court, but it clearly places a great deal of emphasis on the fact that these leases being reviewed in Ward versus Brown were perpetual leases. Now, that seems to be the heart of Ward versus Brown. We then move to this idea of benefits and burdens. I hope you'll look at that test of benefits and burdens very closely, because what are the benefits? The benefits that are asserted in the.
Well, it sounds like to me the benefits are that they occupy these things and essentially treat them like their own property.
Your Honor,
am I missing something here? I think if you rode up on the street and looked at it and watched it over a period of years, it would look like, for all practical purposes, they owned the property. Am I wrong?
Your Honor, you're right, because that's exactly what happens with every lease. If you look at a property, you can ride by the property and look at leased property. Who's in possession?
Well, what I'm saying,
if
you did it here for 200 years, that's what you'd see.
Well, Your Honor, that's an issue about where to draw the line on duration. The legislature decided to draw the line at 99 years. So 100 years, you lose. If it's less than 100 years and you pay rent, because when you drive by, you don't see whether or not the person who's occupying is actually paying rent. You don't pay rent if you're an owner.
When you're saying the improvements, we're talking about the condos themselves, correct?
The building, yes.
And so
any kind of
you're
improvements.
saying that the leases, in this case, say that those buildings belong to the county?
Yes, I am, Your Honor. That's correct, because that's what they say, every one of them. Not one of them says anything different from that.
Well, why wouldn't that just be fair legal title as opposed to, because the difference in practical terms between that and the other is non-existent, because they get the same use of the leaseholder gets the same use of the property. They've got the same practical rights with respect to the property. There's just the difference in the issue of who has the bare legal title.
Well, I would disagree with you, Your Honor, because let's say I'm Donald Trump and I got a nice place on Pensacola Beach. I decided I'd like to have that building across the bay and move it to Gulf Breeze. Couldn't do that. I'm a leaseholder. I can't move that property. I can't move the improvements. They must stay in place. I must improve them. I must keep repairing them if they get torn down. So it's different. We're a leasehold. It's not ownership.
But you still have the right to rent it?
Yes.
And collect the rents.
Just
you
like,
have the right to change it and make improvements, correct?
Yes.
You have the right to encumber it?
That's correct. Just like any lessee.
Okay.
Just like any lessee. And we've shown you the case law in Florida.
You can transfer your interest?
I'm sorry?
You can transfer your interest in that property?
The leasehold interest? Mm-hmm. Yes. Okay. And if it appreciated in time, then yes, you get the appreciation. That is the difference in price. Because it is a leasehold. And a leasehold...
But are those the factors also that you take into consideration when you're talking about whether or not someone is an equitable owner?
I'm glad you asked that question. Because if you have an equitable ownership with a leasehold, here's real quickly what you have is you have a title holder who will not keep the title, and you have a lessee who will wind up with the title. That's not what we have here. What we have here is a lessee, the title holder, Escambia County, who will never lose the title. Escambia County always keeps the title. And you have a lessee who will never have the title. Our clients will never have the title. They don't have any contract deal. Now, This court has stated in the very case.
You're arguing the same case I lost as a lawyer here in the Leon County Educational Facilities versus Hartsville.
That's where I was going.
I mean, you're making the same argument I made to this court way back when, and I lost.
Actually, the difference here, Your Honor, is that transaction was a financing arrangement whereby that facility was going to be owned by the government when all the payments were made. There was an option to purchase at the end of that for $1. There's no option to purchase here at any price, and there's never going to be a transfer of the ownership, the actual title to the property, the improvements, or the land to our clients. So it is different, and that distinction.
So you're saying that there can never be equitable ownership unless there is the prospect for legal title to ultimately vest in the current equitable owner.
That's
now,
what I'm saying.
What case supports that proposition?
Well, that case supports that proposition.
I read it, and I just read it this morning, and I don't remember that being in there.
Well, here's the language and it was not underlined in the opinion of the First District
Well, I've got
Court of
it.
Appeal.
So tell me where it is.
Well, it's in between the lines that are underlined. The sentence says that, and it cites the Gautier versus Lepoff case.
We're talking about Leon County Educational Facilities? No?
Well, it is in that case, Your Honor, but that's repeated in the Areola case. The court said, and they cited Gautier versus Lepoff in the Leon County case. They talked about you don't, just because you have an option to purchase doesn't mean you're an owner. And then it says, we have said that if you have a leasehold, even if you have an option to purchase at the end, you do not have an equitable interest in that property. You do not. If you have an ordinary lease. Now, I say the Leon County
that's not the point. That's not the precise point you've made. That's a different. I mean, you're extrapolating from what's here. What am I missing?
Well, I'm not extrapolating about what the facts were in the Leon County case. The Leon County case said this is a financing deal, and we don't have a financing deal here. But
they don't say that this is the only circumstance under which there's no holding here that that's the only circumstance in which there could be an equitable ownership.
Well,
do they?
By saying if you have an ordinary lease, you have no equitable ownership, then aren't they saying you got to have some sort of extraordinary lease? And that's my point.
Well, an extraordinary lease might be a lease that's perpetually renewable, or renewable virtually perpetually. I don't know, but that seems to be different.
And that's where I was going with my argument, Your Honor. Okay. And that is,
I'm glad I helped you there.
Thank you very much. Because it takes you to this question: are these extraordinary leases? They're not. They're ordinary leases. Whereas in Ward versus Brown, what was before the First District Court of Appeal was in fact extraordinary leases, because they had this lease term that said we're going to renew automatically, and it also said something different from our leases, that the ownership, the title to the improvements were not going to go to the county until the end of the lease term. And the First District said, well, if it's a perpetual lease, there is no end of the lease term. Therefore, the lessee always has the ownership of the improvements. They don't have title, they don't have bare title, but they always have ownership of the improvements, and therefore they should be taxed because they own the improvements. That's an extraordinary lease. Now, what's another extraordinary lease? I say the other extraordinary lease is the lease in which there is this striking a deal where we're buying the property. The lessee is purchasing the property. It's like a contract for deed.
Local taxes shall be authorized for school districts, counties, and municipalities, and may be authorized by general law to levy other taxes. And so you'll find things like the local option penny sales tax, adopted in many counties, has been allowed by legislature, but then adopted in that county by a vote of the electorate of the county. So a state may not assess property values, may not tax based on ad valorem principles, but the sales tax which belongs to the state, can be shared with the counties and the cities, and this provision is one that allows that. Millage limitations, this is a provision that came into the Constitution with the 1968 revision. Is very unfortunate, not very well thought through. The people who served on the Constitution Revision Commission of 1968 were faced with a historic bubble at that time and increase in property values, and tax assessments were going up throughout the state. And so to deal with that problem, the 1968 legislature, acting largely on initiatives that came out of the Duval delegation, where the pressure was particularly high, the legislature adopted this provision on the millage limitations. That is, government units could not assess more than certain mills on property. And so the principle came down that school boards could assess 10 mills, counties could assess 10 mills, and municipalities could assess 10 mills. Well, where did this 10, 10, and 10 come from? It came out of the clear blue sky. It had absolutely no basis at all. It was just somebody wrote down on a piece of paper, and it found its way in the Constitution as a millage limitation. And we'll see some cases on millage limitation, but again, it is, in my judgment, a very bad policy, a limitation on the authority of local government to levy taxes, and that subject should be within local government's authority, in my judgment, and those who now provide for millage over 10 mills or whatever can be accountable at to the electorate at election time. Note that there are also provisions relating to water management districts with different principles applying to the water management district in the north of Florida than those principles that apply to, for instance, the South Florida Water Management District. We move into the borrowing power, pledging credit, and prohibition first that no state, county, or school district shall become a joint owner or stockholder or give, lend, or use its taxing power or credit to any corporation or association. So government is not supposed to get into business, but this will not restrict government from the investment of its trust funds and for the investment of other public funds. Revenue bonds may be issued. The revenue bonds may be issued to finance or refinance capital projects for airports or port facilities or other projects. Now, for revenue bonds, the bonds have to be predicated on repayment of the bonds from the revenue generated from the project. So the state's credit is not pledged when a revenue bond is adopted. Instead, those bondholders, those people who purchase the bonds, have to look to the revenue that's generated by the project that is bond financed by revenue money. And here a special provision relating to electric generating, allowing counties or municipalities, special districts, to be a joint owner of electric generating property. Remember the earlier provision that said that state, counties, and municipalities may not get into business? Well, here's a quick exception, and it's because the Jacksonville Electric Authority wanted to get into business with a power company, a private power company, to build a electric generating plant that each of them would share. And so to allow that, the Constitution was amended, and we have this provision. Again, revenue bonds. Some limitation on the outstanding principal of revenue bonds is contained in Section 11. Provisions in subsection B and C relating to debt service, and allows some flexibility in the combination of bond issues. Revenue bonds may be issued without a vote of the people, so long as the bonds are solely payable from the revenues generated by the project. So bonding may not be done without a vote of the electors, except revenue bonds. And so revenue bonds look solely to the revenue from the project. For revenue bonds, they have to be approved by the legislature or by an act relating to appropriations or general law. So the project itself must be authorized before the revenue bonds will be issued. Local governments have the authority to issue bonds to refinance and finance any capital projects that are authorized by law, but they again have to get the approval of the electors who are owners of freeholds. So the people who are freeholders and not entirely exempt from taxation now are a special category of electors for purposes of bond financing of governmental bonds that call on the general credit of the state or local government. Provision relating to illegal relief from illegal taxes, pretty well self-explanatory. Special provision for bonds for pollution control and other water facilities. This authority must be implemented through law adopted by the legislature, and the repayment can be secured by a pledge of payment primarily from the revenues that are derived from the operation of the facility. So we now have port facilities, for instance, that might be authorized, and bonds can be issued to build the port facilities. Pollution control, again, involvement of a state fiscal agency that puts some restrictions on debt requirement and debt obligation. A provision that allows the leasing of facilities that are bonded to local government. Bonds for pollution control we've talked about earlier. There are limits now on the principal that can be outstanding. So there are limitations on the bonding power of the state. A very specific section relating to revenue bonds for scholarship funds. So you find some scholarship funds in Florida now, pursuant to legislation adopted under this section, now are funded through bonding. Same thing with housing, particularly affordable housing, provided for in Section 16. Section 17 allows for bonding power to be used for acquiring a right-of-way or constructing bridges, with the idea that the bonds can be issued now and that the facilities can be placed into use, but these bonds are now can be issued without a vote of the electors, which is really quite unique. But there is a revenue stream, that is the fuel tax, that can be used to fund the bonds in this area. And note that in subsection B, that's exactly the way the bonds are to work, that they're to be payable primarily from the motor fuel or special fuel taxes. And note that there's a state fiscal agency that assures that we don't issue too many bonds in this area. Provision in section 18 requiring counties to spend funds only on the authorization of the legislature. And funds that have been appropriated by the legislature can obviously be spent, but legislative control over local appropriations is maintained through section 18. Again, there are conditions on laws requiring counties or governments to spend funds. This is a provision that came in with the 1998 Constitution Revision Commission proposals, and is very important provision of, according to municipal and county government, because it now puts restrictions on the state legislature from having requirements for expenditures by local government. So local government may not be required to spend monies for a purpose designated by the state legislature unless, in accordance with this provision of the Constitution, such a provision is approved by 2/3 membership of both houses of the legislature. And the principles relating to the limitation on those kinds of requirements are all in this conditions. Now, we move to a subsection B of that same section, which again says that unless you have approval of 2/3 of the legislature may not have any general law which it will have the effect of reducing the authority of municipalities or counties to raise revenues in the aggregate, so far as that authority existed in February of 1989. So we now have constitutionalized the legislation which was in existence in 1989, and would require some considerable research to dig out and see what that authority was in 1989. Well, that's an overview of finance and taxation. I think you may have gathered by my lecture that I'm not entirely happy with the way Florida has fashioned its finance and taxation system in recent years. Been great responsiveness to Florida taxpayers who don't want to pay taxes, great responsiveness to businesses and enterprises that want exemption from taxation, but we've been left with a system that is totally honeycombed with exemptions. And this whole article begs out for reform, but none appears on the horizon. Again, it's a really important subject for those of you who will be practicing law in the next decade or so, to give more thought to and to think about what you'd really have if you had an ideal taxation system. My submission is that Florida's taxation system is far from ideal. Thank you.